feedback. Before I begin, I'm going to ask the committee, today is the 4-year anniversary of the Nova Scotia shooting. And in honor of the victims and the people of Nova Scotia, I'd like to ask the committee if we can start with a moment of silence. Yeah. I know that this is going to be another difficult day for the people of Nova Scotia, and our thoughts are with them today. I'd now like to welcome our witness from the Office of the Information Commissioner. It's always a pleasure to have Carolyn Maynard here, who is the Commissioner. Ms. Maynard, welcome to committee. You have up to 5 minutes to address the members. You can start now, please. Thank you.
Merci, bonjour. Je vous remercie de m'avoir invité.
Thank you for inviting me to appear before you today to answer questions about my office's main estimates. Since I first took on the duties of Information Commissioner, I've always looked forward to the opportunity to speak to you about my operations and the state of access to information in general.
Of 2023 and 2024, I am pleased to report that my office successfully resolved more complaints than it registered. This helped us make real progress against our backlog of complaints. Earlier this year, I requested additional temporary funding through the Minister of Justice in order to eliminate my backlog completely. Unfortunately, this request was not granted. De plus, je me trouve aujourd'hui devant une situation.
In addition, I am now faced with a particularly challenging situation. As we begin a new fiscal year, I find myself dealing with a structural deficit. To provide a brief explanation, my office received additional permanent funding for 27 investigators in December 2020. Because of the way the Treasury Board Secretariat has calculated funding for last year's new collective agreements, I did not receive money to cover raises for these 27 investigators. This represents a 2 to 3% budget reduction, amounting to approximately $375,000 annually.
Like mine, this is a significant strain. Every employee plays a vital role, and losing even a few can deeply impact my office's ability to fulfill my mandate. This is one more reason why I will continue to advocate for an independent funding model for my office, as recommended by this committee. Following this week's budget announcement, I'm also concerned that the units responsible for access to information across the federal government could find themselves short of staff due to attrition if departing employees are not replaced. Last September, in op-eds published in the Globe and Mail and in Le Devoir, I cautioned that leaders must keep in mind that access to information is not a service. It is a quasi-constitutional right and a legal obligation, and it must be treated as such. Autrement dit, les unités d'accès.
In concrete terms, this means that ATIP units must be resourced in a manner that enables them to carry out what is, I repeat, a legal obligation. In the last year, I have observed too many instances of institutions ignoring their obligations when it comes to access to information. In fact, I currently find myself in a scenario I was assured would not occur when the legislation changed in 2019.
Making powers were added to the Access to Information Act, I had suggested changes to ensure compliance. I was told that these amendments were unnecessary, as my orders would be legally binding. Institutions had to comply with the orders or else challenge them in court. I quickly realized that this was wishful thinking. Indeed, rather than choosing between complying with my orders or challenge them in court, some institutions are choosing to do neither. By ignoring my orders, these institutions are in effect breaking the law. Concrètement, cela veut dire que les
In concrete terms, this means additional delays for Canadians to receive the information they requested and are entitled to. Upholding the Act is at the heart of my mandate. This is why I have been forced to launch my own legal action against institutions that have decided to ignore my orders. As a result, I have now initiated 4 mandamus proceedings before the court to compel compliance with my orders, thereby ensuring that a response is ultimately provided to the requesters.
my resources and those of institutions that are deploying their own legal services to deal with these cases. How much is this intransigence costing institutions? I can only guess. This is not supposed to be necessary, and I am sure that Canadians would agree that it is not something we can afford in the current economic context. It turns out that a culture of secrecy does not only impact our democracy, but it comes at a considerable financial cost. Thank you.
Okay, merci, Madame Maynard, pour...
Thank you, Ms. Maynard, for your opening remarks. We would like to welcome Mr. Martel and Mr. Fortin. We're going to start with our first round of questions, 6-minute rounds. Mr. Barrett. I was pronouncing it in French. You have 6 minutes, please. Good morning, Mr. Chair. Good morning, Commissioner.
Currently investigating ArriveCan, is that correct? Yes. We've heard that Min Doan, who's the Chief Information Officer of Canada under this Liberal government, destroyed or attempted to destroy over 1,700 emails relating to ArriveCan. Is that what you are specifically investigating?
I cannot talk about my complaints or the investigation I'm doing, but it is part of the overall investigation, given that I started my own investigation.
What was the trigger for your investigation?
Well, the number of complaints that we received, the allegations that we saw, the testimonies that you've heard was sufficiently serious that I decided to initiate my own investigation into the affairs of CBSA and ArriveCan.
Are you able to tell us if you've interviewed Min Doan?
No.
No, you're not able to tell us.
No.
He has not cooperated with parliamentary committees investigating his role in ArriveCan. Are you able to compel testimony from Mr. Doan or others who you wish to interview?
Yes, the Act allows me to.
Which Act?
The Information Access.
Have you been able to obtain, are you able to share with us if you've been able to obtain copies of the up to 1,700 emails that are said to have been deleted?
I cannot confirm that.
Are you able to tell us if you have the power to order the production of those emails or any other documents that are relevant to your investigation?
Under my Act, I have the power to subpoena documents and subpoena witnesses.
What are the penalties for obstructing an investigation or for someone refusing to provide documents or refusing to cooperate?
There's no penalty. The only thing I can do under the Act, if I find that somebody is intentionally refusing to cooperate or refusing to provide documents, or if it looks like it's an intent to not provide access to Canadians of some documents, I can refer it to the Attorney General. As soon as it becomes more in the gray zone of criminal intent, I cannot investigate those allegations.
Are you able to say what the remedy is that the Attorney General would be able to offer?
No.
Have you done that in the past?
I've done it 6 times.
Do you know what the outcome of those 6 referrals were?
I've never been aware of an investigation.
So we've seen key players in the $60 million Arrive scam lie to parliamentary committees. We know that the House found one witness, one individual, to be in contempt for prevaricating and refusing to answer questions. Are you witnesses that you interview sworn in do they take an oath before you take testimony from them?
We can ask them to be sworn in an affidavit.
And anyone who swears an oath can be charged with perjury, which carries a penalty of up to 14 years in jail. It's an indictable offense. Is testimony to you protected by the same type of privilege that people who testify at parliamentary committees enjoy?
I don't believe so.
So the cases that you refer to the Attorney General, to the Crown, could be referred to a prosecutor for charges of perjury, as an example. That potential exists.
That would be in the purview of the Attorney General's decision, yeah.
But for the half dozen, and could you tell us over what period of time you've made referrals?
Over the last 40 years, the Office of the Information Commissioner has referred 6 cases.
Are the details or the specific cases that you referred, is that a matter of public record?
No.
Is it confidential?
It's, you can access this under the Access to Information Act.
So would one need to file an ATIP with your office to get that?
I believe if you do an informal request, we probably can provide you some information on these cases.
Ms. Menard, would you be willing to provide that information to the committee?
I will.
Thank you very much. Who else would be subject to your investigation? Like who, we're talking about with respect to ArriveCan. Are you able to share with us what your scope would be, or is that details that you're unable to share?
I cannot, yeah.
Have you so far seen cooperation from the people or from the entities or individuals that you've contacted in this investigation?
I cannot confirm.
Are you able to share with us the anticipated or your target completion for your work? Is that something that you forecast?
I'd like to finish before the end of this year.
The end of the calendar year?
2024, yeah.
And that would mean that you would have, that you'd be able to report on it by that time?
Yes.
Okay. You mentioned how much time do I have left, Chair?
25 seconds.
Commissioner, thanks very much for your response
You're
to my
welcome.
questions. I appreciate it.
Okay, thank you, Mr. Barrett. Ms. Khalid for 6 minutes. Go ahead, please.
Thank you very much, Chair, and thank you, Ms. Maynard, for being here today. Much appreciated all of your work in your tenure. I appreciated your comments about making sure that your office functions effectively, and a lot of that has to do with funding as well. Now, I do note that in December of 2023, the opposition voted against funding for the Office of the Information and Privacy Commissioners as a whole, and as you've said, without. Please don't interrupt me. I don't interrupt you when you speak, Mr. Barrett.
I don't want any disruptions here. Keep the comments down, and I accept your apology, Mr. Couric.
I didn't say anything.
I thought
no,
it was you.
So
No, it was Mr. Couric. I heard it.
My apologies to Ms. Khalid and the chair.
Okay, so I accept your apology, and go
I
ahead, Ms.
expect-
Khalid.
well,
So,
Absolutely. I apologize, Mr. Barrett, for thinking
you.
that you said something that Mr. Couric said instead.
it was well said. Well said.
we are going to continue. I did stop your time. In fact, I'm going to give you the 25 seconds back. You have 6 minutes. Go ahead.
Thank you very much, Mr. Chair. So you had said that without additional funding, I will no longer be able to carry out my mandate responsibly and ensure full respect of Canadians' rights to access to information. And these were the words of the Information Commissioner when Harper was in power and when Pierre Poilievre was minister responsible for safeguarding our democracy. Now, do you worry that receiving ample resources in the years forward or not receiving them is going to hurt how your office effectively functions?
Having sufficient funding is always at the heart of my mandate, because I cannot. I don't know how many complaints we're receiving. I don't know how many investigation we have to do. So this is why I was asking for an independent funding mechanism, so that if it goes down, we can reduce the funding. If it goes up, we can ask for through a mechanism that's faster than the current mechanism that we have that it's providing us with sufficient funding.
I appreciate that. And so as you're entering your final year of your mandate, what challenges do you see going forward for your office? You
referred to the former commissioner, and it's interesting. If you look at the testimony that she did in 2015-16, there's not a lot of differences between what we said back then and what we are saying now. Is the Act needs to be modernized. The government has to change the way that they deal with access to information. They have to be more proactive. They have to provide information because the Access to Information Act is not now responding to the demand. So we have to do something. We have to invest in our resources. We have to manage the information better. And I don't see, since when I started in 2018 and now, it hasn't improved. I don't think it's going to improve in the future either if we don't change.
I appreciate that. And how do new technologies play into the role for the office? Specifically, when we're talking about artificial intelligence, we're talking about digital technologies and privacy concerns specifically. Does that play a role?
Well, the role of new technology for sure would help units responding to access requests faster, removing duplication, going through documents faster. There's some institutions that are already using robots, like bots they call them. RCC is using some of them. But we need to provide that's another example where IRCC has been trying to upgrade their portal where they provide information, and without that, access requests are still going up. So we need to find tools to provide that information in a proactive way, for sure.
And do you collaborate with other departments, et cetera, like, for example, shared services, perhaps, to develop those technologies, or is that a separate thing on your own in your
That's
office?
within the authority of the Treasury Board Secretariat, because they are responsible to administer the Act. So I'm just often providing some example of solutions that could be explored.
And does your office have a plan as to how to deal with these evolving technologies and how we provide services for access to information?
No, we don't. We don't.
Is there thoughts about creating a plan?
It's not within my mandate. So through investigation and through complaints and through our dealings with institutions, sometimes we come up with best practices. And so during meetings with other institutions, I often refer them to these institutions that have good practices. But it's really within the purview of the Secretariat of the Treasury Board President.
Okay. That's fair. And you mentioned complaints. Now, you did indicate on certain files that you have received a lot of them. How do you differentiate between frivolous complaints versus what you would consider as legitimate? Does that take up a whole lot of your time and your resources?
It doesn't, but I know it does impact institutions that have to deal with requests that are made in bad faith or vexatious or frivolous. And under the Act now, they have the authority, they have the option to ask me for not responding to these requests. And if I give them the authority, the approval, they can not respond to these, but they have to still prove that those requests are frivolous or vexatious, and it's not always easy to do.
What does that process look like in your office?
It's a very simple process where the institutions send us the wording of the request, because it's the request that has to be vexatious and or made in bad faith, and then they have to give us the evidence or the arguments why they believe that it's a vexatious request. And we ask the complainant or the requester, they have a chance to respond to the allegations. And based on those two submissions, we decide based on the case law and whether or not the request itself is.
Are you able to share an example of such a vexatious request?
Yeah, we have a few on our website, summaries of those. Yeah, I can send you.
Can you share something with us today?
Well, I think we just approved one actually where the request led to an amount of 2 million pages. And without the cooperation of the requester to reduce it, it would have been such a huge imposition on the operation of the institution that we agreed that the request was not reasonable.
Okay, thank you.
Thank you, Ms. Khalid. Thank you, Ms. Menard. Monsieur Fortin pour 6 minutes, s'il vous plaît.
You have 6 minutes. Thank you, Mr. Chair. Hello, Ms. Maynard. Thank you for being with us. I'm sitting in for Mr. Villemur, who was not able to be here today. And after talking with him, I have a few questions for you. I understand your role as the Information Commissioner, and I imagine you've had to look into the classification level and documents that were redacted, and it's always interesting to see pages and chapters that are redacted. And I was wondering if you believe that there's too much redaction or not enough, or should it be done differently. How do you see the issue of redaction, which causes parliamentarians and Canadians to not have access to information that could be significantly important? I understand that some institutions will automatically redact documents instead of trying to give the most information possible. There are exceptions to the legislation, and they need to be applied correctly. But often, these exceptions are discretionary, and we've noticed that institutions do not use that discretion to give more information, but rather to redact more. Through our investigations, we try to work with institutions so that the information is not redacted and that it be accessible. In certain cases, it is reasonable, but in other cases, we realize that people will be able to better understand decisions made if there's more information given, whereas if the information is hidden, it leads to confusion and questions. So more there is information shared, more there will be trust. Can you explain why that reflex exists? And it seems to be rather generalized in many departments to over-redact. What leads to that? How can you explain it? It's difficult to know. Different institutions have different ways of doing things. I think that they're afraid of giving out too much information or that it will not be well understood. It is a culture in government that needs to change, and it needs to come from the top down. I believe that ministers, deputy ministers, managers should encourage disclosure rather than discourage it, but it's very difficult to make such a culture change. If I've understood correctly, it seems to be quite generalized in different departments. Can you tell us whether or not there's a directive that could come from higher up that states to say as little as possible, or are there different levels of mistrust at different departments? Well, this culture has existed forever. When the legislation was implemented, the goal was to give access to information and to limit exceptions, but the way it's been applied, well, it's the opposite that's happening. The exceptions are being the first things used. It's not something that's happening individually. And tell me, Ms. Maynard, does this have an impact financially, for example, for your office? Does this lead to additional costs, the fact that documents are redacted? Well, people who receive documents that are redacted will have questions, will wonder what's being hidden, and so they can send in a complaint, and this leads my office to receiving more complaints. There are more access to information requests. There are more things that are refused. And so the complainants will reach out to us to have access to the documents. If I talk to you about the Winnipeg report, you know what I'm talking about, correct? I see you smiling, but I see that the answer is yes. If not, you'd say so. And so there was about 600 pages in that report, and pages that were almost entirely redacted. And after parliamentarians who had access to these documents were able to comment on it, it went to the Supreme Court, and 3 justices looked at the document, and there was about 14 pages left redacted over on the 600 initial pages. I cannot speak to this case specifically, but what you're sharing is a problem, because we're seeing the time that it took for the disclosure of this document, and so people don't trust that documents are appropriately reviewed and redacted. That's why we receive complaints that people do not trust that the use of exemptions are appropriately used. Because after an investigation, usually they'll receive more information than what they received initially. Thank you, Ms. Maynard. Thank you, Ms. Maynard. Thank you, Mr. Fortin.
Thank you very much, Mr. Chair, and welcome back to committee. I always appreciate, Ms. Maynard, the candor and professionalism and rigor in which you approach your work as commissioner. You'll note that this committee has long wrestled with access to information, the delays, the structural issues that are, I think, underscored by what you described as a structural deficit baked into your operations. In your opening comments, you referred to your work as a quasi-constitutional right that must be upheld. And you referenced institutions that were negligent in responding to your requests for access for information. I believe you said that there were 4 actions currently underway. Which institutions are those?
There was 4 application of mandamus produced against one. The first one was against Trans Mountain Corporation, TMC. That application was settled. And then I had to apply for mandamus against National Defense 3 times. And one has been also found to be moot because the request was responded to. But we still have 2 active applications
against the Department of National
Defense. Yeah.
So 3 actions, one of them moot because you had to actually take them to court using your own resources on a budget that already has a structural deficit baked in. There's no punishment for not following your orders. In your estimation, does that not incentivize departments to not comply if there's no real repercussions?
It's the fear that we have in my office right now. We hope that it's not going to become a norm.
And with the Department of National Defense, you know, given the strong mandate that you have and all the agencies and institutions that are prevalent, that this one 3 times has required this, does this not speak to a culture within the Department of National Defense?
Whether it's a culture, whether it's a lack of resources, the priority definitely has not been provided to providing access or the appropriate resource to respond to these requests at National Defense.
I would put to you that in my time, my short time, 4 or 5 years here, one of the frustrations I have coming against the idea of open government, the idea of being open by default, the idea of having parliamentary privileges, is that in practice we're often left with very little information to make informed decisions as decision makers in the House of Commons. It's something that we wrestle with. I don't think it's a partisan issue, quite frankly. I think that there's members of all parties who would agree. And in that regard, you know, I think that it's part of our mandate and duty, Mr. Chair, to deal with these things. Now, we had a situation that was a once-in-a-century type situation yesterday because somebody refused to follow the very basic premises of our abilities to send for documents, order for evidence, and make witnesses appear. My concern, and we've seen this with other studies that we've had right here at this committee, is that if people know there's no consequence, then forget about open by default. There's going to be, I think, a culture of cover-up by default, secrecy by default, obstruction by default, negligence by default. You know, and for that reason, Mr. Chair, I wonder if it might be wise for us to seek unanimous consent on a motion that would draft a letter from this committee to the Department of National Defense, urging them, we can't direct them, that comes from the House, recommending to them that they comply in good faith with our Information Commissioner. The fact that we have, you know, a cash-strapped commission having to take legal proceedings, the fact that in the House of Commons in the last session of government had to have the Speaker of the House go after the government to get information is a problem. But in this situation, I think in a nonpartisan way, by seeking unanimous consent, a letter comes from you to the Department of National Defense asking them to comply with the demands from the Commissioner in accordance with the Act and in accordance with her mandate. It's not something I want to get into a filibuster over.
Yeah.
But I do think the testimony we heard is compelling. One department has a pattern here, and I think that should be a request. It's a very reasonable, rational request that's not a demand.
Okay, so I'm going to stop you there and accept that as a motion.
Thank you.
And I think it's a reasonable motion as well. And of course, now that the motion's been moved, we have to seek debate on that motion. And I appreciate the fact that you don't want a long debate on it, but I'm going to open the floor. And Madame Menard, if you can just hang on for a sec. I see Ms. Khalid on what Mr. Green has proposed, and then Mr. Barrett. Go ahead.
Thanks, Chair. Just seeking clarification, is there something similar going on at the National Defense Committee?
I wouldn't know that. And
I
if
have no opposition to this.
Say that again? Okay, thank you. Mr. Barrett?
Yeah, this makes great sense. Appreciate the motion coming forward. We'll support it. Mr. Green is in the process of reading minds down the table. I was going to say that we should make it time bound, and so I'm not sure if similar requests have been made. I don't personally have a suggestion, but that they should comply sometime in the future. I'm sure they've made overtures that at some time in the century that they will, but that's obviously not acceptable. So make it time bound, but certainly it has our support.
So I'm going to seek some guidance from Ms. Maynard on this. What would be a reasonable timeline if the committee were to agree to what Mr. Green has proposed, in your opinion?
So what you need to understand is I already ordered the National Defense to respond to a request, and they said they would comply to the order. Under the Act, you either comply or you go to court. In this case, they said they will comply, and they didn't. They missed the date. So that's why I'm in court to force them to respect an order that has already been issued.
Okay, so Mr. Green?
So the timeline is it's already too late.
Passed.
I just reflect in terms of our order of operations that my fear is that we'll have the same treatment unless we put a date. And so, you know, I think if it's 2 weeks for a response from the time of the passing of the motion, then that would at least give them the opportunity to respond to this committee with what their intention is.
All right. Can I make a suggestion then? Perhaps within a month? Sure. A month from the date of the letter being written? If that's acceptable to everyone, I think that's a reasonable timeline. I will advise the committee that there is nothing binding to this, nope. So that we're all aware of it. But based on what Mr. Green is proposing, I think it's a reasonable request. It may or may not help Ms. Menard, but what will help is the fact that the message has been heard by this committee. So I'm going to seek unanimous consent on what Mr. Green proposes. Okay, we're good, good. Not seeing any dissension. Okay, so that motion carries. We're going to continue on. Unfortunately, that's the end of your time,
that's
Mr.
fine.
Green.
Yep.
We're going to go to Mr. Couric for 5-minute rounds. Go ahead, Mr. Couric. Thank you, Mr. Green.
Thank you very much. And thank you, Commissioner, for both coming again before the committee and for your work. And just to highlight, you talked a little bit about the quasi-constitutional right to access. Maybe that's something in a perfect world where that would be articulated as a constitutional right, because I think that open and transparent government should certainly be the default, and it is incredibly frustrating that we have this culture of secrecy that exists. And I would like to, in a little bit of a follow-up to the conversation, so you referenced, and I apologize if I missed it, but there were four of the six. You referenced six in your opening remarks. One was with TMC. Four were with the Department of Defense. Did you mention what the other?
It was 6 to the referral of the investigation to the
Okay.
Attorney General, but 4 application of mandamus, 3 against DND and 1 against National TMC.
Okay, I appreciate that being clarified. So there are those 4 current proceedings before the courts. Now I think that we find ourselves in an interesting circumstance because you being given order-making power, and it would have at one point in time been seen to have been enough to name and shame. We've had similar conversations with now a series of ethics commissioners where a $500 fine for breaking the ethics rules was at one point seen to be the punishment of being exposed to have broken the ethics rules was enough. And certainly, you having been assured in the beginning that, don't worry about it, no penalty, it's not a big deal, because of course they'd want to, and I'm being a little bit facetious here, but Madam Maynard, Commissioner, what would be an appropriate penalty to ensure that that we don't have this culture of secrecy perpetrated upon ultimately Canadians who are denied access to their information?
It's really hard to tell what would make institutions understand their obligations, the fact that it's important that they respect the law, and that the requests must be responded within a certain time, and that the orders of the commissioner must be complied with. Who's responsible ultimately? Is it the unit who's responding, the minister, the people between? It's to find those, that would be a difficult task to determine where did it break. But a penalty, we don't have penalties under the Act. The Commissioner of Official Languages was just provided some penalties with his new Act. It's going to be interesting to see if that has an impact.
Right.
But I would love to have performance objectives where maybe, some people would be required to respect the obligations under the Act.
So, to pivot back to the, when criminality is involved, you refer those cases to the Attorney General. It seems to me that it would be possible that that's a little bit like a black hole. You don't see the result of that, and certainly Canadians don't see the result of that. So I'm just wondering, does there need to be transparency in that process? So that if you see criminality, if there's that need for that referral, does there need to be a public reporting mechanism? Because certainly I would like to know that the 6 cases that you've referred, what the deal is with those. Are cabinet ministers implicated? Was there criminality within departments? Those are open questions that I think should be fair ones to ask. Yet we have this black hole currently that exists administratively, that from the good work that your office does, coming against the wall of prosecutions, and then all of a sudden it is a Liberal-appointed Attorney General that is then responsible for the decision-making process of what to do with possible criminality that could have significant political consequences. Do you see a concern with that with that process?
Under my submission for the amendments to the Act, I suggested that it be changed to a referral to the appropriate authorities. So that would be opening my authority to refer to the RCMP or to another police authority.
Right.
But right now, it's very specific. It has to be referred to the Attorney General.
So there could be right now alleged criminality that is not being investigated because it would be easier for the Attorney General to simply make it go away?
Very quick.
It's their decision. It's within their authority to decide what they decide to investigate or not.
Wow.
Thank you.
Thank you.
Thank you, Commissioner. And Mr. Kirk, we're going to go to Mr. Fisher for 5 minutes. Go ahead.
Thank you very much, Mr. Chair, and I want to thank you for that moment of silence at the start of our meeting. I certainly, as a Nova Scotian, very much appreciate it. Commissioner, welcome. Thank you very much for coming today. In the main estimates, your office is asking for just over $15.3 million, which is an increase of 1.1, or just over 1.1 million over last year's. Can you tell me what that 1.1 looks like, what that represents, and how those funds would be used?
We received, the last time we received an increase was in 2020, and it was with respect to the amendments to the Act. Anything we get, we invest in our investigators. The number of complaints that we receive are increasing every year. So we put that money into more people to investigate faster and to eliminate our inventory as quickly as possible.
So, notwithstanding the way you would like to see your office funded, based on the number of complaints, is this budget increase going to be sufficient for your office to fulfill the mandate? You feel comfortable with that number?
I didn't get an increase in the last 3-4 years. I requested $2 million per year for 3 years in the last budget request for a temporary funding, but that was not provided.
Okay, so this is the first increase then in the last few years? This 1.1?
I don't really know where the 1.1 comes from, because the last time I received money was $3 million a year since 2020. Is it possible it's the Privacy Commissioner you're referring to?
No, the OIC. It's seeking 15.3 million, an increase of 1.3 over last year's main estimates.
I think it was provided to us in terms of, now I think I understand what you're saying. It's the additional funds for collective agreements for all of our employees, because we are mainly we have all I would say 75% of our employees receive an increase in the last 4 years.
Right.
So that would be covering that.
I think you may have touched on this with Mr. Kirk, but with regards to the Access to Information Act, and you did say that there were some amendments made to it, but you said that you pledged to continue advocating for changes to the Act and to the system. And I'm wondering what those changes might look like. And I know you did touch on, I think you touched on one with Mr. Kirk, MP Kirk, but could you maybe talk in broad terms what those changes might look like?
Well, first of all, I think that the Act, because it's 40 years old, needs to be modernized in terms of like what it's the purpose of the Act. We need to, right now I don't have access to cabinet confidence, so those documents are not reviewed by my office. So that's something I think is problematic, because the section to say that something is cabinet confidence is being used more and more, and there is nobody independent from the government right now investigating those documents. I think that they actually be also applicable to Minister's Office and the Prime Minister's Office as well, and so broadening the application of the Act. Those are some of the submissions and recommendations that I made to this committee during the review of the Act.
Thank you for that. In your departmental plan, you said you're going to continue to do everything possible to continue the trend that you established of improving performance and being more efficient. Can you tell me what some of the things that you might have done to do that, and if that's something maybe we could use as a blueprint for other departments, because we're always looking for ways of being more efficient?
Well, when I arrived as new commissioner in 2018, that was the first thing that I set in motion, is to be more efficient, so that investigations are done in a timely manner. So we added tasks and timelines to all of those, and we follow them. We don't give extra unlimited times to institutions to respond to us anymore. You know, it used to be, because we have so many files, we could leave them, we have other files to work on, but when we open a complaint, it's assigned and we finish it, so we don't put that back in a drawer. Those are the type of things that we really focused on, and we invest all our money on investigations, on the training for that, and providing guidelines to our investigators so that there's consistency as well.
Thank you very much.
Thank you.
Oh, okay.
Thank you, Mr. Fisher. 5
Thank you.
minutes. Monsieur Fortin pour 2 minutes et demie.
Mr. Fortin, you have 2.5 minutes. Thank you, Mr. Chair. Ms. Maynard, in 2.5 minutes. I'll try to be quick. The 4 mandamus requests that you talked about, were there any non-publication orders? No, it is public. So you can tell us who are the people who are implicated. Is there any defense? While we're looking at resources, we need to give these files to our lawyers, and they need to spend time with an application to the federal court to force an institution to meet its obligations. What are the 4 institutions? As I stated, there's Trans Mountain Corporation, TMC. That's one of the first institutions that had refused to respect an order, and National Defense for the 3 other files. And to the mandamus request, in the 4 files, what was the defense? Currently, we're preparing documents for a hearing. There were affidavits made, but currently there has not yet been a debate. There hasn't been a written defense by D&D to say we will not be cooperating for such and such a reason. Not yet. And you said there were affidavits. Is there anything that's been alleged by D&D? I cannot give you any details. Currently, I can say that it's usually a lack of resources that keeps them from responding. This is your understanding. Is this what you've been told, or has this been written to you, that they say they need more time, they don't have the resources? I would have to closely examine the affidavits because every case is different and it's really a case-by-case basis. If you'd like, I could come back to you with the reasons after looking at the documents from the Department of National Defense. I would appreciate that, Ms. Maynard, if you could share the affidavits that were sent or the written procedures that explains National Defense's position and that of Trans Mountain. And I see that my 2.5 minutes is over, so thank you. Thank you, Mr. Chair. Apologies, Mr. Fortin. Your time is up.
Go ahead, please.
Thank you very much. And so Mr. Fortin quite adequately expanded on the process when you have to refer to court. If I recall, you had mentioned there were 6 cases that you referred to the Attorney General, and yet we've only explored 4 of them that went forward publicly. So would you please share with committee what were the other 2 cases that were referred to the Attorney General but not acted upon?
So it's 2 different things. Like the 6 cases that I refer, or that the office referred to the Attorney General's, were with respect to investigations where we felt that there was reasonable evidence of an intent to obstruct the access request.
Which ones were those?
So there's, I will have to send you a list because some of them have been before my time. But it's usually because we believe that there's a possible criminal charge coming up. The 4 mandamus are separate. Yeah.
Okay, just so for the purpose of this committee and for the purpose of the good and welfare of open and transparent government, I would put the request that you do submit that list of referrals to the Attorney General's office for reflection of this committee in response to the work that you're doing. Mr. Chair, at this time, I'd like to just move a notice of motion. I won't be debating it, but I do think that it's in keeping with the trends of the lack of forthrightness and truthfulness at this committee. And so the notice of motion, which will be distributed, I'm not moving it, I'm just tabling it today, that in relation to the testimony provided by Google during their committee appearance on December 13th, 2023, where Ms. Jeanette Patel stated that Project Nimbus is not directed at highly sensitive or classified military workloads that are relevant to weapons or intelligence services, and recent reports that the Israeli military is using artificial intelligence for surveillance and to identify targets for airstrikes in Gaza, and contracts signed in December 2024 between Google and the Israeli Ministry of Defense for the further build-out of the Google Cloud platform, that the committee write to Google and seek clarification on their previous testimony and to provide information on whether Project Nimbus or other Google Cloud services are being used to support AI-targeted airstrikes in Gaza, and that Google respond in writing within 15 days of receiving the committee's letter, and that should Google fail to meet this deadline, that the committee shall request the following people to appear before the committee at the earliest possibility: Sabrina Jeremiah, VP and Country Managing Director for Google Canada, and Sam Sebastian, VP and Country Manager for Google Cloud. So I'm tabling that now, and that will be submitted to everybody in both official languages for their consideration at future meetings. But certainly, Mr. Chair, having people mislead this committee is something that we should take very seriously. So with that, I'll concede the rest of my time with Ms. Maynard. Thank you.
Okay, thank you, Mr. Green. So the motion has been put on notice, and the clerk is in receipt of the motion, and that will be distributed in both official languages. Thank you. Mr. Barrett, 5 minutes. We've got 2 5-minute rounds left. We're going to go Mr. Barrett, followed by Mr. Housefather. You'll conclude. Go ahead, Mr. Barrett.
I'd like to circle back to the point that you've raised. You raised in my first round and in the round with Mr. Couric, talking about ArriveCan. So we have you have an ongoing investigation. I appreciate that the details of that you can't get into it, but we have allegations that a senior official, chief information officer, Mindone, is alleged to have deleted 1,700 emails, maybe more, we don't know, destroyed documents in a case that is of great public interest. Obviously, this frustrated the work of the Auditor General of Canada, and certainly there's other potential investigations that are happening with the Royal Canadian Mounted Police. They've indicated that they are, in fact, investigating ArriveCan. So in an investigation, if you find that a government official has deleted or destroyed government documents, what is the consequence that is meted out for a violation under the Act?
So there's 2 things. Administratively, somebody could have destroyed or erased emails, and I don't have any penalty. There's no, like, if we arrive to the conclusion that the documents don't exist anymore, we can make a finding and we can produce a report. But if I find that there's reasonable evidence that it was done intentionally, so that it was to remove somebody from having access to these documents, my only authority is to refer to the Attorney General for future investigation.
Commissioner, I'm having a very hard time with this, and so we have a situation where individuals that you're investigating, like in the ArriveCan scandal, as an example, can lie to you, can commit perjury, can be found to have intentionally destroyed documents to frustrate investigations, and the maximum penalty that you can apply is a referral to the Attorney General. Is that correct?
My only authority is in those situations, yeah.
So herein lies the problem, because, as has been pointed out, the Attorney General sits in the cabinet, has been appointed by Prime Minister Justin Trudeau. This situation is incredibly politically sensitive for the government, and we have an independent officer of Parliament who goes to great lengths to get answers, to get access to information, to ensure that basic transparency laws are being adhered to, and the Attorney General, who, as I said, is a Liberal cabinet minister, is the arbiter of whether or not it goes any farther. And I just can't see how that ensures any kind of confidence in our public institutions and or the efficacy of the work that you're able to do. What's the solution to this?
I think separating the investigation of a criminal investigation to administrative investigations is the appropriate thing for an agent of Parliament. But as submitted earlier, it would be maybe better to have in the Act that I can refer these type of cases directly to the authorities in charge of investigating those type of criminal charges.
What's the precedent for that? Does that exist with other officers of Parliament?
If you look at the Federal Act for judges in the court, any court, judges can refer if they find during during a hearing, during a process, evidence of an intent to commit a criminal offense, they can refer to any authority that they want to.
What about the lobbying commissioner? Does she have to refer cases to the Attorney General, or
I don't know.
She refers them to the Royal Canadian Mounted Police? So I find it incredibly troubling that we have a situation here. I think Mr. Kirk rightly put it. We end up where they go into a black hole, and that's not how we restore confidence in our public institutions. Thanks very much.
Thank you.
Mr. Barrett, Commissioner, Mr. Housefather, 5 minutes. Go ahead.
Thank you very much. Merci, Madame la Commissaire. I'm going to come back.
Thank you, Madam Commissioner.
Was the Act amended since 2015 to change the provisions about how you would refer matters to the Attorney General?
No.
So it wasn't this nefarious act by the current government to change the law so that you can only refer matters to the Attorney General that existed while Mr. Harper was Prime Minister?
It's been like this since 1983.
Since more before many of us were even born. Okay, thank you very much. I wanted to ask you a question, coming back to delays. You had talked a little bit about how you've been clearing the backlog, and I know when you were first appointed, I saw a CBC article from April of 2018 that said they had done an investigation at that time, and there were 267 complaints that were more than 5 years old. Do you know how many today are more than 5 years old?
I don't have that, but I can provide that to you. We're now, I think, less than 20 cases prior to when I was appointed. And my goal is really to reduce the backlog to 2 to 3 years max, which is still long. But we do have cases that are extremely complex. And so we're working on trying to have, an inventory that's very flowing instead of growing.
Well, I congratulate you on that, because we certainly prefer flowing to growing. Can I ask the question, like, in the United States, as I understand it, you can go to the federal court or whatever the American court that would be applicable to an access to information claim weeks after you file. But they don't have a position that's analogous to yours. Is that correct?
Yes.
And here, the way our law works, you would only be able to go to court after you'd already ruled on a claim, correct?
Yes.
And that could lead to potential delays of years if the process isn't flowing faster, which then means that the material that people are asking for are so out of date that it's almost irrelevant. So can I ask, what can we do to help your job of making this flow faster, other than just giving you more money, which would be the obvious answer to that, but I don't know that I have the authority to do that?
Having more resources when complaints are increasing, that's definitely a solution. Having less complaints that are not necessary to come to my office would be also very helpful. And that sometimes when I do systemic investigation, as you're going to see in May, I'm going to be submitting to you a report with respect to immigration files and with possible solution there where the government can provide information otherwise than having people having to submit access requests. And that's going to reduce the number of complaints that would come to me and will give me more time to work on the real complaints that I should be getting.
Mais ça, c'est une bonne idée parce que j'ai entendu avant que
I heard earlier you stated that you can send out an informal request. And when I was a mayor, we did something similar. I never required anything, but we always had a practice where if somebody asked, we tried to share as much as we could. And so if departments had a similar practice, would that make your job easier? Yes, absolutely. Proactive disclosure would be better, and we encourage institutions to give out information. And often it's the same things that are asked, so they could offer this information voluntarily instead of waiting for a formal request. Are there any departments in government that have any best practices that we could look to? All institutions are struggling with meeting their obligations. When we publish information, it needs to be published in both official languages, and that's often an excuse that is given to me, that it's costly. But I believe that if people did that from the beginning, knowing that the information would be shared, that would reduce costs.
45 seconds.
I will see at the time. Thank you very much. Thank you, Commissioner.
Thank you.
Okay, thank you, Mr. Housefather. That concludes our questioning today on the estimates. Commissioner, on behalf of the committee and on behalf of Canadians, I want to thank you for appearing before the committee again. Like Mr. Green, I really do appreciate your frankness, and I know that you're in a difficult situation right now. You've got a lot of work that you're dealing with, and perhaps a lot of work ahead. And if there's anything that we can do as a committee to help you improve your work and the efficiency of your office and your staff, then always feel free to contact myself as chair, and I can certainly bring that to the attention of the committee. So thank you again, Commissioner. Thank you. Okay, so we're going to continue on. We've got one order of business that I need to deal with, and it involves the budget for this study that we're doing. It is in the amount of $2,000. That includes headsets and some other expenses as well. So I'm going to seek unanimous consent of the committee to approve the budget. I see left of me, I've got that. Right side, I've got that. Thank you. And so the budget is approved, Madam Clerk. Seeing no other business, I am going to adjourn the meeting. I want to wish you all a very good. Go ahead.
Talk about the letter?
Yeah, I was going to bring it up, but I'm still dealing with some stuff. Ms. Khalid's referring to. I'll bring it up then. I don't want to get into a prolonged discussion. As you know, the committee dealt with a motion the other day to defer the report of the social media study. We received a letter from ISED saying that they would be 200 days. I thought that Ms. Khalid brought up a couple of good points the other day that I want to seek clarification and guidance from the committee. I think we should write back to ISED, and rather than this open-ended 200 days, I think we should ask for more specificity on when they can expect this to be done, because I know how important this study is to the committee. I don't want it to, basically sit there not being dealt with, and I think if we get that clarification from ISED. So what I talked to Ms. Khalid about, I'm not sure how I can format this. We'll figure it out with the clerk and analyst, but if it is the will of the committee, I would like to write a follow-up letter to ISED asking for more clarity on the timelines. They said it was going to be 200 days, and as we discussed the other day, we didn't even know whether that was based on when the security review was announced in September or whether it was as of the date of the letter on April 19th. So that's what I'm looking to do. If I have the approval of the committee to do that, I'll draft it. I can send it out to you for your benefit to see before I actually send it to them, and that way you can provide comment on that. Go ahead, Ms. Khalid, on that.
Thank you very much, Chair. First off, I really appreciate you revisiting this. I know that this study is quite important to members of the committee. So yes, I think that we do need to seek confirmation on the timeline, but there are two other points, if I may.
Go ahead.
That we'd like to hopefully include in the letter. Now, a lot of media reporting has indicated that the review was triggered by a business expansion. So I'd like for us to also confirm that that is the case of the nature of the review. And also, like from Section 2 of the Investment Canada Act, the purpose of this act is to provide for the review of significant investments in Canada by non-Canadians in a manner that encourages investment, economic growth, and employment opportunities in Canada, to provide for the review of investments in Canada by non-Canadians that could be injurious to national security. Now, I'm not sure how that really relates to the complete substance of what we have been studying. So I would like to seek a little bit of clarity about the National Security Review to assess the data harvesting and the data sharing practices of TikTok, or is it related to a pending commercial transaction? I think having an understanding as to the nature of the review would perhaps help guide us better with how we turn out our report.
Okay. I appreciate those 2 points. That's something that, in my view, we can include in the letter for clarity. I don't see any discussion on those 2 points that you bring up. So, like I said, we will draft the letter. I'm going to send it out to members of the committee in advance of it being sent, so that if there's any comment